there is a hierarchy of rights. It says 25 is a hierarchy of rights. 25, the subjection clause must be viewed as a hierarchy of rights, and therefore the Constitution provides for a hierarchy of rights. That example is directly given in Association for Democratic Reforms. Complete obiter in my respectful submission. Page 131 I have given.
Those are all cases not arising under 25(1). We have to make a distinction.
Kindly see.
You can't just apply like that.
Precisely, Milords. That relevant extract of ADR is at page 131, Milords. It says, for example, page 131, I have quoted it, para 150. For example, Article 25 of the Indian Constitution, which guarantees the freedom of conscience and the profession, practice, and propagation of religion, is subject to public order, morality, health, and other provisions of this part. And this is given as an example of hierarchy of rights, Milords. My respectful submission, Milords, the integrity of Part 3 demands that there be no hierarchy of rights. Milords, now coming to the test, which is at page 135, Milords. At 136, Milords, for lack of time, I'm straight away skipping to the test, Milords, because perhaps, again, this is inspired from the Venkatramana Devaru formulation, para 40 at page 136. For the purpose of harmonizing two conflicting rights, whether reflected through a social reform welfare legislation or in the absence of a legislative measure, the following balancing test is applicable. What is the nature and extent of the restriction on an individual's fundamental right caused by the religious practice? In the case of a social reform measure, what is the harm to the individual's fundamental right that is sought to be remedied? This is the first question. 2. Does the religious practice in question arise from sincerely, conscientiously held religious beliefs of a denomination protected under 26B, read with 25(1)? The Parsi case is an example of this. Whether they can prove that the exclusion of a married Parsi woman who is married to a stranger is a conscientiously held belief under 26B. C. If the religious practice in question is permitted to continue, can the individual still exercise their fundamental right meaningfully? D. Is the proposed measure to restrict or reform the religious practice the best of all feasible alternatives to effect minimal restriction on the denomination's right, but also to enable the individual's right in an equally effective manner? Because if this test, this is partially inspired by Venkatramana Devaru, partially inspired by the proportionality principle, Milords. This is what I have tried to highlight here. Milords, your Lordships will see the table of contents only to see the range of topics that I've attempted to cover in my note, Milords. Milords, in the last leg of my note, Milords, I have attempted to say that perhaps, Milords, our reading of our Constitution must be more indigenous, in the sense that I have attempted to suggest, Milord, that Swaraj, how the term Swaraj was employed by Mahatma Gandhi, by Aurobindo, is perhaps something that is nearer to our practices to understand how we read 21, 25, 26 extra. I've made that attempt at page 200.
You said make it Indianization, don't go for Oxford.
Not just that, because Swaraj, Milords, according to me, Milords, and this is a conception of Justice Mohandas Karamchand Gandhi as well as Sri Aurobindo, is not just external. It has an internal element. It has spiritual freedom. It has dignity. It has self-respect. In none of the judgments of this court on dignity, self-respect, have we ever relied on an Indian doctor.
First person to use that concept was Lokmanya Tilak.
Tilak was there, just prior to Tilak, Milords. It was Sri Aurobindo's brother who started writing about the concept in his letters to Sri Aurobindo, Milords. Bharindra Ghosh, Milords, I think. Milords, even on dignity, self-respect, Milords, this court could have used Suya Maryada, etc., which has Indian roots, Milords, but we have always used elements from abroad, Milords. So that is what I've attempted to say in that last portion on Swaraj, Milords. I am grateful for the time, for the opportunity. Thank you. Grateful, Milords.
Starts, Lord. So we have a little query. Your Lordship has wanted an amicus who has given a lecture which has nothing to do with what we argued or what they are. Now, are we to treat him as the inner chamber of judges, which will then advise your Lordships? Because what he has argued has got nothing to do with what we argue or what they argue. And this creates a very serious one.
It might have.
No, this is an unfair comment, my lord. It
I-
might
I- I-
multiply our burden, Mr. Dhawan. It might multiply our burden. You people are relaxed.
My lord, I have a serious objection to this comment, my lord.
Completely unorthodox. It is totally, but not inconsistent with the adversarial system we follow. But not when we have been amicus, we take a position one way or the other. Now the difference is that this is a reference case. Now what they were supposed to do, as we understood it, is given our arguments, responded to them, given their arguments, responded to them in a way that would be understood by your lordships and ourselves. On my part, Lord, I find no relevance whatsoever as part of the computation.
My lord, I'm sorry, allow me to say something, my lord, on this. My lord, please allow me to say something.
Brother, I don't share that perspective. I don't share that perspective. Brother,
Lord,
if you
I-
have anything to say, we can put in a note. I don't
Yeah,
share
absolutely, my
that.
lord. My lord, kindly allow me to say something.
Mr. Dhawan, the point is that he has given his own perspective about 25 and 26
I don't.
and read with other parts of the constitution.
Brother, I,
So let me say, Lord,
brother,
You have a right to disagree.
I think the amicus is.
All of you have, all of you have a right to agree or disagree or partially agree, partially disagree with the amicus. That's why we are granting exact 2 weeks time. By 29th May, all of you are entitled to submit your revised comprehensive complaint.
my lord, may I say something, my lord?
But
My lord, may I say something?
Which
Perfectly fine.
and I'm going to sit down now.
My lord, may I say something?
Thank you. Thank you, Mr. Gay.
My lord, may I say something, my lord?
Just a minute.
My lord, kindly allow me to say, my lord, I strongly object to this kind of, my lord, an objection raised against an amicus. My lord, amicus is appointed by your lordships and he is not supposed to satisfy either Mr. Dhawan or other side.
Exactly.
Lord,
That's
he
what
has
we are
given
saying,
his
that we
own-
have given a perspective.
That's why.
Lord, we do not lose our civility.
Anyway, Mr. Singh, I think,
My lord, we do not lose our civility by pointing out that Mr. Dhawan is a party in person in this matter. But, my lord, let it be that way. But I would request Mr. My lord Singh, my lord, Mr. Shivam Singh, not to be cowed down by this. My lord, he is a young man.
On their case, I was trying to sue.
You should not have been wearing your gown, Mr. Dhawan. You should have removed your gown and argued. You are party in person. No counsel is objecting to this.
Like was, to which we cannot understand.
Yeah.
I leave it.
no, sorry, there is no need of submission. Yes, Mr. Singh, 2 minutes.
My lord, I would request Mr. Singh. Lord, I'm only a minute, Mr. Singh. I would request Mr. Singh, he is a young counsel, a brilliant counsel. He need not get cowed down by such observations. My lord,
No,
all of us on both sides
don't-
are
nobody
by
trying to
standing
cow
by him.
down or anything. These are all opinions coming. That's all.
Let's move on.
So it was really unfortunate.
Mr. Singh,
You
how
cannot
do
bully
you
your
read?
younger colleagues.
I'll take about 5-7 minutes. I won't take more than that.
Just 5 minutes, please,
Yes.
because we are also.
I thought I'd take 10, but anyway, your lordships, I'll just address the point. I'll just address the point in question. Sir, I'll just give it to you.
Have a note?
Sir, what we have done for everybody's benefit is that all the submissions that have been formulated vis-a-vis the 7 questions which have been raised by this honorable court, we've prepared a tabulated grid saying that who has addressed which question in what manner. Your lordships will find that is first done for the review petitioners. Then there are their detailed submissions. After that, we have done
It's
that.
in a way compilation of both sides that what has been asked.
Absolutely, your
Very good.
Absolutely, your lordship.
Text of submission.
Yes, your lordship. So in that regard, it is this index which is available. It is a grid-like summary. Then there is a detailed summary of all the arguments repeated for the writ petitioners, your lordships. After that, there's just one issue which I wanted to address, that of constitutional morality. Your lordships, day before itself indicated that your lordships have heard this in extenso. So I would not urge your lordships to consider every point of it. All the case law, your lordship's attention has already been invited to it. There are just 2 or 3 paragraphs from my written submissions that I wanted to specifically invite your attention to, your lordships. And those paragraphs which are available, your lordships, I would just urge, and your lordships may mark it. These are para 63 and para 70 to 72. Your lordships, I'll just summarize these in a couple of lines And your lordships, on the aspect of constitutional morality, the strongest criticism which has come about is to say that this is a relativistic doctrine, it is a value-based doctrine, and it is without any textual foundation. Whereas the strongest defense which has come for this constitutional morality doctrine is that it is an essential check against majoritarianism, and even basic structure is a judicial innovation. So if 13 of your lordships could consider basic structure to be part of the constitutional setup, then there is no reason so as to discard constitutional morality in that framework, your lordships. On most issues which your lordships have been addressed on, probably the strongest position on those aspects has been taken by Mr. Vaidyanathan on all those arguments, and a contrary perspective has been on the other side has been taken by Mrs. andRajeev. On this aspect of constitutional morality, the strongest criticism which has been leveled has been that of the learned SG, and the strongest defense which has come about in this regard has been through Mr. Shadan Farasat, where he's talked about the basic structure equivalence, your lordships. In my respectful submission, the idea or the conception which your lordships may deem it to be the appropriate one would lie somewhere in the middle in terms of what has been placed by Mr. Raju Ramachandran, Mr. Ravindra Srivastav, and Mr. Gopal Shankar Narayanan, that there is some value or there is some element of usefulness which is associated with retaining it as a doctrine, and at the same time not using it as an overarching basis to invalidate legislations. And to make good this argument, your lordships, I'll just para 70, 71, and 72 of my written submissions are a complete answer to that. I won't go beyond that. Your lordship,
Para 70 and 71.
70, 71, and 72, your lords. Page 142 and 141 to 143. Your lordships, and just to contextualize it and make it in the simplest possible form, I've used an analogy of sports, particularly cricket, so as to ensure that your lordships are able to grasp it in the correct form. Your lordships, when it comes to legislation and invalidation of legislations, there are only three remedies or three areas on which it can be invalidated. The first being Part 3 violation, the second being 7th schedule or legislative competence violation, and the third being any other constitutional provision, more often than not, that is sometimes traced to Article 265. Now, your lordships, my submission is that please employ constitutional morality to understand the depth of the violation of a right and do not use it as a standalone or a supplementary ground to strike down the law. Please employ constitutional morality as a doctrine to reflect on why a law has violated a constitutional provision. And let me just analogize this to cricket, your lordships. Now, in cricket, what we see is that, and the idea being the spirit of cricket, or generally sportsman spirit. Your lordship, there are recognized modes of dismissal as per the laws of cricket. You can be declared out for LBW, bowled, caught behind, etc., etc. You cannot be declared out.
In sports law.
I know, I've written the foreword for it.
He's an
That-
expert on sports.
I've written the foreword for it.
Yes, he's a chip of the old block. He reminded me exactly of his grandfather, Mr. D.P. Singh. I had the great privilege of knowing him.
Grateful, your lordships. Grateful. Now, your lordships, on this aspect, wherein the spirit of cricket, which is relevant to understand, you can be declared out in the recognized forms of dismissal. You cannot be declared out because you are violating sportsman spirit. You can use spirit of cricket to understand that what is, say, stumping or what is, say, run out. Some person is deriving a advantage and the fielding team is alert, and therefore they're able to run this person out. So please use the spirit of cricket or constitutional morality to reflect on what is the reason behind such a provision being there, but do not use it as a standalone basis so as to invalidate a legislation, because then that creates a problem. And this, your lordships, in fact, in this regard, this was an argument, in fact, raised by Dr. Dhavan in the morning. In this context, that when we are seeing as to what is constitutional morality, we've traveled a long line of decisions. We've dealt with all those cases, whether it's the Narula case, GNCT Delhi, etc., etc. So on all these aspects, what is relevant is that please do not have a freestanding power available so as to annul a legislation, because number one, a presumption of constitutionality will always attach with a constitutional piece of legislation. That's number one. Number two, your lordships, is that constitutional morality is extremely abstract in its forms because it is nebulous and it can be varied from person to person. And just as I offered in my analogy prior, that the spirit of cricket can be understood by different umpires in different ways, your lordships. Constitutional morality can be understood by the most learned of judges in different ways, and that may not necessarily align with the aspect on how a legislation should be struck down or invalidated, your lordships. And having said that, your lordships, and since I'm the last person to address your lordships, please accept my deep sense of gratitude for all of your lordships who have heard this matter across so many days, your lordships. I would also like to place my appreciation for my entire team who has been assisting in this matter, especially my clerk, your lordships, who has done a lot of the heavy lifting in terms of the preparation, and for the guidance and support of all the senior members of the bar, as well as the younger members of the bar and the nodal councils who have probably worked tirelessly and who have taken the lead in ensuring that your lordships receive the best possible assistance. I'll leave it to the senior members of the bar to address
My
it.
lord, we join the learned amicus. My lord, for the extraordinary
Really, my
hearing,
lord,
my
a
lord.
privilege and a pleasure
Privilege.
and a learning experience, my lord, to address this on.
The same thing is for us also. We also learned a lot.
None of us, my lord, are leaving
Only
the
one
court
submission.
with any dissatisfaction that we were.
This reference.
Thank you very much to all of you, the kind of cooperation and the quality assistance that has been provided to all
It's
of
an
you.
intellectual treat.
Please, my lord.
Sometimes we kept on asking so many irrelevant questions completely out of context. But the way the patience and the response you give, that was also very remarkable.
Please, my lord, only one line submission. Only one line submission. My lord, only one line
Judgment
submission.
reserved. The part stroke interveners shall be requested to submit comprehensive compilation of the written submissions, subject to the condition that earlier written submissions or supplementary submissions shall stand withdrawn.
Solicitor. Solicitor.
Request of Hastri also to file the.
Asking some question.
You're right. No need, no.
No, supplementary you can give, comprehensive you want to give, because we don't want that comprehensive.
Whatever you see,
Don't say shall, maybe withdrawn, subject to
Mr. Giri,
the earlier.
For your lordship.
arguments were commenced. Today is the 18th day. This reference is an offshoot of Shabrimala. The 18 steps.
Yeah, yes. That's
Dumb.
There cannot be a better person than my brother. There cannot be a better person than my brother to say this, because he himself is a Guru Swami.
I hope we don't have to
Thank
withdraw
you
the
very much.
submission.
Thank you all of you.
obliged to your lord.
Saying that you can submit